worries.
All right, great. Well, thank you everyone for coming to the housing rights training today, the tenants rights training today. My name is Maddie Nation. I'm a senior policy analyst with Homebase. Homebase is a nonprofit technical assistance provider that works with HSA to support providers working with folks experiencing homelessness in this community. Today, I am joined by two co-presenters. We're going to hear from David Carducci from Legal Aid of San Mateo County, as well as my colleague Esther Wilch. And we've got a great training planned for you all today. Before we get into it, I wanted to turn it over to our partners at HSA to see if they had any kind of words that they wanted to say at the beginning here. Kalia, do you want to add anything?
Hey, sorry. Good afternoon, everyone. Khalif Arsh with the Human Services Agency. Just want to thank everyone for making time for this training. Excited to have training, especially Dave Carducci. And there's some updates in the past few years, so we want to bring this training back. I know it's typical favorite with everyone, so I hope you all learn something new and get a refresher on existing tenants' rights. And thanks to Homebase for coordinating. Maddie, I'll turn it back to you.
Great. Thank you so much. If folks have questions today, we will have time to pause for questions, so feel free to add those in the chat. We're also hoping that folks can generally stay on mute during this training unless you are asking a question. And if we have any issues with that, I'm happy to help. So without any further ado, David, do you want to take it away?
Yeah, thanks, Maddie, and thanks, Kalia. I guess, Maddie, I don't see the chat. If you see questions in the chat, feel free to pause at a good moment, and happy to entertain questions as we go along. Particularly questions about, clarifying what we're talking about. If there's long questions about a particular client, happy to talk to anybody offline about a particular client. Those questions don't always work so good in a presentation like this. But if you can help me with the questions, that'd be great. Good afternoon, everybody. Thanks for having me for this housing rights training. I'm the directing attorney for the housing team at the Legal Aid Society of San Mateo County. Our mission is to prevent homelessness. So I wish I could put all of you out of business and put myself out of business, but unfortunately, I know there's a lot of housing issues out there for people, and we're going to talk about the laws that apply and tenant protections and the processes out there that applies to tenants here in San Mateo County and around the state of California. And again, appreciate being here. I've given you my direct line, my direct phone number on the opening slide and the final slide. Like I said, you're all welcome to call me anytime if you want to talk about a client or particular housing issue. My email address is up there also. For clients, at the bottom there is a housing intake line. You want to give clients our housing intake line to contact us when they need our services. Not my direct number, of course. I don't do intake very well. And there's our website there, and we have a lot of resources on our website, including a lot of our housing handouts. So people can go to our website and get our services when they need us. So with that, let's dive into the substance of the training today. Let's see. Of course, I'm hitting page down, and now there we go. So when we're advising tenants, whether it's us or you or anybody out there advising tenants, just like to kind of go over the big picture framework for how we approach advising tenants. Number one, they come to us with a problem, so we listen to them and we try to identify what their issues are and try to focus them. We know our clients can be hard to focus them sometimes, but try to focus them in on the particular issues that they have and what we might be able to help them with. From the legal perspective, next we try to figure out what laws apply to their situation, what the rules are or the processes of the laws. And then from there, we like to discuss their options with them, explain to them what their options are, and sometimes what the consequences of those options are. And the goal there is to let them make an informed decision. We don't tell people what to do. We don't tell them what to do with their lives or with their housing or anything in particular. Sometimes between the options and what the consequences are, the what to do is kind of obvious. But in the end, it's their decision to make, and we just try to help them come to the decision that makes sense for them. As we all know, our clients face a lot of challenges. Finances and the high cost of rent is a big one around here, of course. Their education level, sophistication level, language barriers, limited language abilities, disabilities, physical and mental. And then, our clients are coming to us often because landlords are forcing a difficult change upon them. Maybe often asking them to move out or trying to force them to move out. And that can put people in crisis mode because everybody needs a safe, affordable home. So that's the approach we take. When we're advising tenants, one of the first things we need to understand is what type of housing they're in, because different types of housing has different types of laws and different types of procedures and processes. And that's, we only by knowing what type of housing they're in do we understand what their situation is and what their rights are. So some of the most common types of housing we see for our clients is there's, private market rate rental units, apartments or single family homes, where there's no government subsidy, there's no subsidy for the rent. It's just they're paying the market rate. But then there's a lot of subsidized housing out there. There's federally subsidized housing units, privately owned, but subsidized by HUD funding, or there's public housing units. Not a lot in this county. A lot of other counties have more public housing, which is like owned and operated by the local housing authority. I think we only have like one or two in this county up in like South San Francisco. But like the privately owned HUD housing, Light Tree Apartments in East Palo Alto comes to mind as that type of property. And then what we have a lot in this county is Section 8 housing subsidy vouchers. The tenant gets the housing voucher from the housing authority, and then they go rent from a private landlord. And then the housing authority with HUD money pays usually a majority of the rent, and then the tenant pays what they can afford. So Section 8 program is very popular in this county. Other types of subsidized housing, especially in this county, is below market rate units, or what we might call tax credit properties. These are not deep subsidies like the HUD subsidies, but they're rents that are lower than the market rate. And a lot of the new developments that go up are required to have below market rate units in them. And again, all this matters because especially with subsidized tenancies, because as we're going to talk about later, requires good cause to terminate before the tenant loses the subsidy, the housing subsidy. But other types of housing we have in this county, mobile homes or trailers or RVs, recreational vehicles that are found in mobile home parks or RV parks. This is often a source of affordable housing for our low and moderate income residents here in this county. So that's very important. And they have their own set of mobile homes have their own set of laws under California law. And then there's a lot of ADUs, accessory dwelling units, in-law units, houses that are rented to multiple people, like each renting out a room, or you might have a single renter in an owner-occupied house. And some of these have their own separate rules. And then there's two cities now in our county that have actual real rent control. East Palo Alto, which has had rent control for a long time. And our new member of the club is Half Moon Bay, that recently passed an ordinance imposing real rent control rules for residents of Half Moon Bay. Some mobile homes also in the unincorporated part of the county will have a rent control. So saying all this for the point of when you're talking to a client or a tenant about what's going on in their tenancy, knowing what type of housing they're in is very important, determines what their rights are in many cases. So now we can't talk about tenant protections in California without talking about the Tenant Protection Act of 2019, also known as AB 1482. That was the assembly bill number at the time, and it kind of stuck. A lot of people still refer to it as AB 1482. We call it the Tenant Protection Act, or the TPA, and went into effect at the beginning of 2020, just when the pandemic was hitting. But it's in effect now, and it really break it down to two main things that the Tenant Protection Act does. Number one, it limits the amount of rent increases that landlords can give to their tenants. The increase is according to a formula, which is 5% plus the consumer price index rate of inflation for that year, and with a maximum cap at 10%. So in the last 4 or 5 years when the law's been in effect, it started off kind of lower when inflation was down. It was around 6% total for the rent increase cap. But then when inflation went up, the allowable rent increases went to 9% or more, or even capped out at 10% at one point. Right now, I think it's 8.8% for this year, which is the limit the landlord can increase rent on a TPA protected tenancy during a 12-month period. So that was important to help rein in some of the really high rent increases that could really hurt tenants when they couldn't afford it. The second thing is anytime you have any kind of controls on rent and rent increases, you have to add good cause to evict. So now tenants under the TPA can only be evicted if there's good cause. Now, it could be because they did something wrong, which is called at fault, or it could be because the landlord has legitimate business reasons to end the tenancy, which is called no fault of the tenant. But the point is now the landlords have to have good cause to evict as defined by the statute, and they have to put it in their termination notices. Now, the Tenant Protection Act doesn't apply to all tenancies, but it applies to many of them and the more traditional tenancies. But the tenant does have to be there more than 1 year before the law kicks in. So in the first year, you don't get the protection of the Tenant Protection Act. But after you've been there a year, if you're in a building that is older than 15 years, and it's like a regular apartment building, then you're going to be protected by the Tenant Protection Act. Now, there are some exempted properties, landlords that don't have to comply. If they're renting out a single family home to one family or their condo, TPA does not apply to those rentals. Or if it's an owner occupied home and not too many tenants living in the home with the owner, those are often going to be exempted also. But for the most part, if your tenant is in a normal apartment building that's older than 15 years, which is most of our clients, of course, then the Tenant Protection Act is going to apply to them. So moving on. The common issues for tenants that we see, and that we're going to talk about during the training, is I've got a list of them here. The tenant gets a eviction notice, termination notice from the landlord trying to force the tenant to move out. There's lots of different types of eviction notices or termination notices. There's 3-day notices, there's 30-day notices, there's 60-day notices, there's 90-day notices. It all depends on the type of tenancy and the reasons for the eviction. And we'll get into some of those soon. Unlawful detainer is the legal name for an eviction lawsuit filed in court. Eviction's a 2-step process. Step 1, eviction notice. Step 2, landlord has to go to court and get a court order. So we'll talk about that more coming up, of course. Um, the notice to vacate comes at the end of the eviction case. If somebody is in the eviction process in court and they lose the case, they get the notice to vacate from the sheriff, and that's the last warning that the sheriff is coming to put them out under a court order. So sometimes that's the first time we see a client is when they come to us with the notice to vacate, unfortunately. And we'll talk a little bit about what we can do, if anything, at that point. I spent a lot of time talking about evictions because that's what forces our clients out of their home and sometimes into the streets or into shelters, unfortunately. So I'm going to spend a certain amount of time talking about evictions today. It's important to understand the process. But we're also talks about habitability complaints that tenants have and the landlord won't take care of the property. Fair housing and housing discrimination is a big issue we deal with a lot. Esther is going to handle most of the fair housing training today, so I won't touch too much on housing discrimination claims. Landlord-tenant relations, complaints about harassment or unfair treatment or illegal entry into the home, things like that. We hear a lot of complaints from tenants about that, and there's laws that apply to all of that. Lockouts, not legal lockouts, but illegal lockouts without a court order. We still see those from time to time. Some landlords try to bypass the court process and just kick the tenant out without without going to court and getting the court order. It's totally illegal. And finally, we're not going to talk about it today, but we get a certain number of former owners of homes or tenants of homes that have been foreclosed on. We haven't had a lot of foreclosures in recent years. But it's still something else that takes somebody's home away and puts them out of their home is the foreclosure process. Maddie, any questions out there so far?
No questions yet, but if folks want to add things to the chat, I'm happy to read them out loud.
I'll keep cruising along. So let's talk a little bit about evictions, because like I said, that's the crisis that people come to us with most often. Landlord trying to end the tenancy and force people out of their home for one reason or another. So there's different types of notices depending on if the tenant is alleged to be at fault or not at fault. So for at fault tenancies, the most common one we see still is 3-day notice to pay rent or quit. No secret, rents are high. Incomes have not kept up with the rents. The most common reason still for people to be evicted from their home is failure to pay their rent or alleged failure to pay their rent. We'll talk about that more, but that's still the number one reason why people are getting evicted is because one slip up, one trip to the hospital, one breakdown of the car, one sick child and missing work for a while, next thing you know, you're missing a rent payment and you can find yourself faced with eviction. But other types of notice at fault notices that we also see are if the landlord alleges the tenant is violating the lease, doing something illegal or violating the lease, like disturbing other tenants, for example, or causing damage to the property, creating a nuisance, stuff like that. There's two types of notices the tenant might get. They might get a 3-day notice to cure the lease violation, which gives the tenant a chance to fix whatever they're doing wrong. For example, let's say there's a no pet clause in the lease and they brought a pet dog home, not a service animal for a person with disabilities, but an actual pet. Maybe that pet hasn't caused any harm yet, so they might get a 3-day notice to get rid of the dog or the pet or else. The other type of 3-day notice is to quit for nuisance or incurable lease violation. If the tenant has already done something serious that has caused harm and can't be undone, then they can get a 3-day notice, 3-day notice to just move out. And if they don't move out, then the landlord moves on to the second stage of the process of going to court, filing a court case. So there's some tenancies don't have to be ended with some fault of the tenant, and they don't even have to state the grounds in the notice. For example, a tenant could get a 30-day notice to end a month-to-month tenancy if they've been there less than a year, or if they've been there more than a year, then they get a 60-day notice to terminate their month-to-month tenancy. But if it's not a TPA protected tenancy, then the landlord doesn't even have to state the actual reason for the termination. Um, and then they still have to go to court and get their court order, but the notice doesn't have to state the grounds. Now, a lot of tenancies out there, especially now, do require good cause to evict. The landlord has to have a good legal cause to do the eviction, and they have to state that reason in their notice. Any government subsidized housing, including below market rate and tax credit properties, have to have good cause. A tenancy protected by the Tenant Protection Act, somebody who's been there over a year, gets a 60-day notice, and the landlord has to state the good cause in the notice. A tenant with a Section 8 voucher is entitled to state notice that states the grounds for tenancy, and landlord has to have good cause to terminate. Any rent control or eviction controlled city, the landlord's going to have the good cause and state the good cause. Mobile home tenancies, because of the nature, how difficult it is to move a mobile home. Mobile home tenants can only be evicted with good cause, and the notice stated, good cause stated in that notice. And if you have a fixed term lease, for example, like a 1-year lease, and you're in the middle of that lease, the landlord can't just end that tenancy unless there's a violation of the lease, and then they'd have to give a notice terminating the lease for a lease violation. So we talked about eviction being a two-step process, and step one, termination notice, gives the tenant a certain number of days to move out. And if they don't move out for whatever reason, they can't find a place or they want to fight the eviction, whatever the reason, landlord has to move on to step two, which is filing a court case. I don't want to get too deep into the weeds on the legalities of the court case. That's not the point of this training, but I do want to cover some of the stuff so you understand there's a process and there's a timing and there's things the tenants can still do to fight the case or to reach a settlement with the landlord that puts them in a much better position, and sometimes even win the case. So if we talk about an unlawful detainer or a UD, that's the lawsuit that gets filed with the court. It's filed in the state superior court. In this county, the main courthouse is in downtown Redwood City, but there's other courthouses in the city of San Mateo and South San Francisco. When the tenant gets served with the court papers, this is a really important one. When they get served with court papers, get served with a summons, they have 10 days, 10 court days to file their response with the court. So, I'm hoping if you ever see somebody coming to you and they've got the court papers, I hope you're referring them to our office, refer them to Legal Aid Society right away, or Community Legal Services of East Palo Alto. They also have eviction defense attorneys there. Those are the two agencies in this county that help people with these cases for free. So at that point, it's in the legal process, and the tenant's going to be best off if they get legal help. As far as I'll talk more about the timing, but the way it works is that the tenant files their response with the court within the 10 days. Then the landlord can ask, their attorney asks that a case goes to court, and then the court schedules 2 court dates. They schedule a settlement conference and they schedule a trial. And that's about 2 or 3 weeks after the landlord requests that the case gets set for court. The important thing here is the settlement conference, and that's because most cases do reach a settlement. The landlord and the tenant agree, and we'll talk about what those settlements look like. but they usually reach an agreement. It's very rare for a case to actually go to court or go to trial. But there could be a real trial in front of a judge or a jury if there's no settlement, if the two parties really want to fight out the legal issues and the factual issues in the case. So I want to talk a little bit more about the timing in these things, because again, timing is really important. Where somebody's at in the process is really important. The sooner they act, the better when they get served with a court case. We get clients that come to us and they might tell us a terrible story about landlord doing terrible things and very unfair things. And you say, well, what's going on? Where are you at in the court process? Like, oh, this happened 3 months ago. I'm out of the house. It's like, well, that's very unfortunate, but now it's too late to do anything. Or, it might be the very end of the process and it's hard to do anything at that point. So that's why I like to explain the timing in these cases. So the first step is the landlord files the case with the court, and then they serve it on the tenant. Serving on the tenant means they hire a process server, and the process server goes out to the tenant's home, pounds on the door, tries to get them to open the door, and then hands them the court papers. Now, sometimes they just drop the papers on the doorstep or stick them in the door or do something with the papers if the tenant doesn't open the door. Our advice is, as soon as you see those papers, get an answer filed, at least within 10 days of when you got them. Because if you don't respond on time, you lose the case automatically and you never get your chance to reach a settlement or fight the case. So after they file the answer, you get a settlement conference in about 18 to 20 days after the landlord requests it. So it's just a couple of weeks after you file your response, then you're going to be going to court and be talking about settlement. If you don't settle, then 3 days later, you're going to trial. And if you go to trial and you lose, if the tenant goes to trial and loses, then the court order for eviction is called a writ of possession, if the plaintiff wins, if the landlord wins. And then the lockout by the sheriff can come about 15 days later after the trial. Unfortunately and fortunately, the sheriff's kind of backed up with evictions. It's taking them longer to get out and actually do the lockouts. Sad because there's so many of them, but at least it's giving our tenants a little extra time to figure out what they're going to do if they lose the case. So here's what it looks like on a calendar. Again, this timing is so important that I like to illustrate it a couple different ways. This is a hypothetical month where the first of the month is a Sunday. Process server comes out and serves the court papers on the tenant on the first day of the month on a Sunday. Then the tenant gets the 10 court days to file their response. So on this calendar, that's Friday the 13th, coincidentally. And that's answers due here. That's when they file their answer. Following Monday, the landlord can go to court and say, give me my court dates. They get their trial within 20 days, which is on this calendar, the third of the following month. And I messed up. The settlement conference is supposed to be on the Tuesday. I have it here on the Monday. It's supposed to be on the Tuesday. But you'd have the settlement conference here on Tuesday the 31st. And hopefully the case would reach a settlement. If it doesn't reach a settlement, then 3 days later it goes to trial. The tenant loses, then eviction could happen about 12 days later, about a couple of weeks after, or a week and a half after, if the sheriff is moving fast. So when somebody asks me how long does an eviction take, I tell them about a month and a half if things don't go well for you. So no matter what, from the day you get served with the court papers, you're still going to have about a month and a half before you can be forced out. That's the good news. The bad news is if you get all the way to the end, you've lost a case, you got an eviction on your record, and the sheriff is escorting you out the door with 5 minutes notice when they come banging on the door. But point is, you get about a month and a half after the process. The process takes about a month and a half to go through. So now if the tenant is in the court case, they might have defense to the actual case. So what the landlord might be doing might be illegal. And they have the right to fight that court case. It's supposed to be a chance for both sides to present their case and have the case fairly determined, or again, the parties negotiate a fair settlement, all things considered. So common defenses that we see for a non-payment case, the first question is, does the tenant actually owe the amount of money that the landlord claims is owed? So a non-payment case always starts with the landlord saying, you didn't pay me this amount of rent. It's a specific amount. Could be for 1 month, could be for multiple months if the landlord waits for some reason. And the first question is, does the tenant actually owe that amount of money? And sometimes, the tenant makes payments and the landlord doesn't give them credit for it for one reason or another. Sometimes maybe a landlord gave a tenant an illegal rent increase under the TPA. Lots of different reasons why maybe the tenant doesn't owe the money that's alleged. Other common defense in non-payment of rent cases is breach of the warranty of habitability. That's the landlord's obligation to take good care of the property and keep the property in livable condition. If the landlord fails to maintain the property, the court can actually reduce the amount of rent the tenant owes and order the landlord to make the repairs. So that's a common defense that's raised by tenants in these cases. Now, in the cases where the landlord has to have good cause, like the tenant did something wrong, or has to have other good cause to do the eviction, the defense is the landlord doesn't really have good cause, or the allegations are not true. So if they've alleged that the tenant has breached the lease, violated lease terms, oftentimes the tenant disputes that. So that's not true. That's not how it happened. It was somebody else, or I was provoked, or acted in self-defense, or whatever might be the case. So that's how tenants defend those cases. In the cases where the landlord doesn't have to state the reason, it's still illegal for landlords to act out of retaliation or discrimination against the tenant. So the landlord doesn't give a reason, but the tenant says, hey, wait a minute. The real reason here is retaliation. I called code enforcement on this landlord because they wouldn't fix the place, and they got mad, and now they're evicting me. That would be illegal retaliation. Now you have to prove the state of mind of the landlord, which is never easy to do, but it is a legal defense in these cases if the tenant can prove it. So as I've said several times, most cases end in a settlement, doesn't go to court, the parties reach an agreement, 90% of the time, maybe more. Landlord and the tenant and their attorneys, if there's attorneys involved, are going to get together, consider the facts, consider the law, consider the likely outcome if the case did go to court, and then try to craft a settlement that works for both sides, that both sides can agree to. You got to consider the tenant's situation, what their priorities are, what their limitations are. If you're trying to keep the tenant in the home, can they afford the rent going forward? If the tenant has to move, how much time do they need realistically? And, how much time can they actually get through the process? Many tenants are concerned about their rent history, or the public record. Is there an eviction on their record? And so that's it's very important to a lot of tenants who come to us. They say, I just want to make sure that this doesn't go on their record. And the way to do that is reach a settlement, and that if the tenant does what they're supposed to do under the settlement, it's very common that the case will get dismissed, whether they move out or whether they stay, and then the case won't go on their record. And that's because evictions don't automatically go on the tenant's record. It only becomes a public record if the tenant loses the case through the court process. So the types of settlement agreements that we help tenants negotiate. First type of settlement is called a pay and stay. That's, non-payment of rent case, but the tenant comes up with a payment plan of some sort, or they get rental assistance money. They can get the rent that the landlord is owed, and they want to maintain the tenancy, and they can pay going forward. So we try to negotiate terms for a pay and stay. Now, sometimes the landlord's attorney, the landlord had to hire an attorney and had to pay that attorney, and sometimes they ask the tenant to pay the attorney's fees. That's often part of a settlement, and that can add $1,000, $1,500, sometimes even more to a settlement, which can make it hard on the tenant. But landlords can do that. Sometimes they can be negotiated away also. If the tenant has good legal defenses and the landlord doesn't want to go to court, sometimes they'll let the tenant stay and waive the attorney's fees. Like we're talking about, the tenant always wants the case to get dismissed at the end of a settlement so it doesn't go on their record. And that's usually a term condition of the settlement. As long as the tenant does what they say they're going to do, make the payments they need to make, then the case gets dropped at the end and doesn't go on their record. And the alternative, if the tenant says they're going to pay a certain amount and then they don't pay it and can't pay it, then the landlord usually has an easy path to get an eviction order, despite the fact there was a settlement, because the tenant couldn't live up to the settlement. They breached the settlement, and then the landlord still gets their eviction order. Tenant gets put out, and then in that case, often it is going to become an eviction on their public record. The alternative type of settlement, if it's not a pay and stay where the tenant's staying in the unit, then the alternative is maybe the tenant has to move out. Maybe they have to agree to move out. Maybe because they can't afford this home anymore. Maybe because circumstances are landlord's not going to let them stay for various reasons. So the tenant has to agree to move out. Tenant surrenders possession by a specific date that they agree on. Sometimes the landlord will waive the rent or maybe even pay the tenant on some occasions, not too often, but some occasions, pay the tenant to move out quickly. Landlord wants to get the process over with. If the tenant is agreeing to move out, but staying for an extended period, like maybe an extra 2 or 3 months, they'll probably have to pay rent for those extra 2 or 3 months. And then if the tenant moves out on time, then the landlord agrees to drop the case, and then it doesn't become an eviction on the record of the tenant, which is what the tenant wants. But if the tenant doesn't move out, the landlord can usually get a fast eviction in those situations, and then it could be on the public record.
David, we have some questions in the chat if now is a good time to pause.
Yes, it's a perfect time to pause.
Great. So the first question we have is, for East Palo Alto, is the entire city have rent control or just certain units?
Yeah, good question. So almost any tenant protection law usually has exemptions. So I'm not an expert on East Palo Alto rent control law. The attorneys at the Community Legal Services of East Palo Alto are better with the details in here, but in general, it applies to most, the types of tenancies that are covered under the Tenant Protection Act. I don't know if it applies to single family homes or not, actually, offhand. It applies to most tenancies though, but I think there's some exemptions. I'm sorry, I can't get more specific.
Okay. Our next question is, for how long will it stay on their record if a tenant loses a case?
That's a tricky question. I don't know the exact answer to that. You hear different things out there, and there's different places where an eviction can show up on a record. So there's the court records. And if the tenant wins, the court records don't become public, so nobody sees the court records. If a court record becomes public because the tenant loses, I believe court records are forever. I don't think courts ever, purge their records. I think, you can look at cases that happened many, many years ago in the court through the court's access to the court's records and websites. So I don't know that the court record ever goes away. Now there's also the the credit reporting companies, and they can find out about these eviction cases, and they could end up on a credit report. And I've heard that like 7 years is common for a negative, like a negative credit event can be on a credit record, but I'm not an expert on credit reports and how those work. So, it's just something tenants really want to avoid, because it's like at least 7 years or longer is what I've heard.
Thank you. Our next question focuses on habitability. If the home is rented and the appliances like stove, fridge, washer, and dryer are provided, is it the landlord's responsibility to have them checked and repaired, or is it the tenant's responsibility?
We'll talk more about habitability real soon, but the question about appliances, that it has more to do with if the landlord provides the appliances, then yeah, the landlord should maintain that they work or replace them if they don't work, because it's like part of the rental. If it comes with the rental, then it's part of the rental, and the landlord is usually going to be the one that repairs those or replaces those. My only hesitation is it's not exactly a habitability question. Habitability means when the place is not livable, like when there's mold or rodents or water leaking and stuff like that. That's what we think about when we think of habitability. An appliance, a stove not working properly, can definitely be a problem, but not necessarily make a place completely unlivable. So it's more of a part of the agreement, part of the lease agreement, where the landlord's providing those, then the landlord will take care of them. Should have to provide them. It's like included in the rent. So if you're paying your rent, then the landlord should provide all the appliances that they agreed to provide.
We have 3 more questions in the chat. Do you want to take those, or do you want to keep moving with your presentation?
I love questions, and we're addressing specific things people have. So keep them coming.
Okay, so next question. When do landlords have to give a 90-day notice to pay or quit?
The answer to that is never. Anytime a tenant is behind in rent, it's only a 3-day notice to pay rent or quit. There is a law. Well, let me stop. It's almost always a 3-day notice to pay rent or quit when the tenant doesn't pay their rent. The 90-day notice comes for Section 8 tenants if they're being evicted for reasons other than serious lease violation or non-payment of rent, then a Section 8 tenant gets a 90-day notice. It's recognized that it takes longer to find a home if you have a Section 8 voucher. So the law allows 90 days. But if it's a serious lease violation or non-payment, even a Section 8 tenant still gets a 3-day notice. And I just have to condition that upon, during the pandemic, there was a law called the CARES Act. And the CARES Act had for subsidized properties get 30 days. Instead of just a 3-day notice to pay rent, tenant gets 30 days. But there's no such thing as a 90-day notice to pay rent or quit. It's either a 3-day notice to pay rent or quit, or for some subsidized tenancies under the CARES Act, they're going to get a 30-day notice.
Okay. The next question, if there's an agreement between tenant and landlord, is the landlord obligated to give back the security deposit?
The security deposit has its own specific law that applies to pretty much all security deposits. it limits the amount the landlord can collect upfront. Security deposits cannot be non-refundable. After the tenant moves out, the landlord deals with the security deposit only at that point, and they can keep security deposit money to pay off rent or for cleaning or damages that is needed for beyond normal wear and tear conditions. So that's generally how security deposits get dealt with. But landlords have to follow the law with respect to security deposits. They can't be non-refundable.
Okay. And our last question for now is the landlord's attorney fee, which the tenant is asked to pay part of, what is negotiated?
Yeah, it's negotiable as part of a settlement. So as the landlord is saying, here's what I want. I want you to pay the back rent, and I want you to pay my legal fees. Let's just say $1,000. The tenant can try to negotiate that they don't want to pay it, or they'll pay less or pay half or something like that. So it's negotiable during the settlement. If the case goes to court, then kind of the law and the lease take over about whether the court can order the attorney's fees paid. And that depends on if there's a provision for attorney's fees in the lease agreement and who wins the case. If the landlord wins, they might be entitled to get the attorney's fees paid as part of a court order. Or if the tenant wins, actually the tenant could get the landlord have to pay the tenant's attorney's fees if the tenant had an attorney. But generally, it's part of the negotiation in the settlement process.
Great. We got one more question while you were answering that one. Can you give
Sure.
an estimate of the legal costs involved in evicting a master tenant, including any attorney fees or court filing costs?
Yeah, from generally what I see, I think it's about $300 for the landlord to file the papers with the court. It's roughly $100 or so for hire the process server to serve the papers on the tenant. Could be a little more, could be a little less. And it's common for landlord attorneys to charge anywhere between $800 and $1,600 flat rate just for their legal fees. So, that's roughly between 1,200 and 1,200 and, 1,500, 1,600, 2,000. There's a range because it depends on the attorneys, of course, and what they charge. Those are the amounts that we're seeing out there.
Okay, great. That was all of our questions for now.
All right, I'll move on to the next slide. We're still talking about court cases. If the tenant loses the case, touched on this earlier, the landlord gets a writ of possession. They take that to the sheriff, and the sheriff is the one that enforces the eviction order. So not the landlord, though the landlord knows when the lockout's occurring, and the landlord's supposed to be ready to change the locks at that time. But it's the sheriff the one that forces the tenant out of the home at that point. At the point that the tenant gets the notice to vacate from the sheriff, giving them a specific date they have to move out on, at that point, the tenant has one last chance to ask for additional time from the court. They can ask for one extra month, but they have to pay rent for that extra time. So like if their rent is $2,000 a month, they'd have to pay to the court upfront $2,000 to get that extra 1 month in the home. And they have to apply to the court, and the judge has discretion. The judge does not have to grant it. The landlord can object if there's some reason why the landlord doesn't want that tenant to be there any longer, maybe if they were causing problems. But that's the end of the road there. Either the sheriff shows up or they get one last extension of time. And then the tenant's forced out of the home if they lose the case. Or if they don't follow through on a settlement and they lose it that way. I'm leaving the eviction process slides and moving on to other issues. So Are there any eviction questions that I should touch on before I leave that topic? Okay, great. Let's talk a little bit about habitability. Habitability is when the landlord doesn't take care of the property and the place is not livable. I like to say landlords cannot rent their property as is. It's not like selling a used car. Landlords have to rent a place that is habitable when they rent it. Some of the required things we think about: the plumbing has to work. You have to have hot and cold running water. You have to have a heater, heater that works. The electricity and lights that work and they're safe, not exposed or dangerous wiring. The roof, the walls, the windows do not leak water, not broken, they're secure. The common areas are clean and trash is removed regularly so doesn't attract rodents and roaches. Shouldn't be, rat infestations, shouldn't be an over amount of mold or cockroaches. Trash cans to keep the trash from overflowing. Again, regular trash service is important. Safe floors, stairs, railings, so that it's safe to walk around the property. Window screens on the windows, keep out the elements and the bugs. There's specific laws under California that, identify all these things and require the landlord to provide the habitable home. Key point: anytime a tenant comes to you and says there's a problem, there's a condition with the home that is causing a problem, the first question, the most important question, is who caused the problem? Who caused the condition to exist? Because sometimes it's neglect of the property by the landlord, but sometimes it's something that the tenant did. And, for example, a tenant can cause flooding if they, clog up a sink or a toilet or a tub or something. The tenant can do things that can cause problems. And then, they're responsible for what happened, not the landlord. But often it's the landlord who's neglected the property or just something goes wrong and they need to repair it. So the cause of the problem is an important question in a habitability situation. So what do we advise tenants when they come to us with uninhabitable conditions? If we think it's the landlord's responsibility, first thing, got to put it in writing. Have to put the condition in writing. You have to write to the landlord and tell them this is the problem that exists and request the repair. If it's not in writing, the landlord's going to deny later that you ever told them about it. So very important to document it and put it in writing. If you don't get a response, put it in writing again. If you don't get a response the second time, put it in writing a third time, if you can afford the time. Take pictures, take notes, have dates, get witnesses. If you're going to have to prove the condition, then you're going to want to have the evidence to prove it. Pictures, of course, are the best. And, send those to the landlord. Look at this mold. Look at this water leak. Look at this flooding, whatever it might be. Now, sometimes that works. Most landlords want to take care of their property. Most landlords want to get those notices. If there is a problem, they'll send their repair person out and take care of things. It's not financially a good idea for a landlord to not repair their property. But there's plenty of landlords out there that don't fix the properties when asked, and as much as they should, they neglect the property. Even when they're asked, even when the tenant brings it to their attention. So what do you do in that situation? The landlord's not responding. Something the tenant can do is report the problem to code enforcement. Most cities and the county have code enforcement officers, people who will come out and inspect the property. And if they find violations, code violations, building violations, they will write a report, issue citations, threaten fines, and order the landlord to make repairs. And that usually gets the landlord's attention. Sometimes it makes the landlord very upset, but sometimes that's what it takes to get the repairs that are needed done.
David, in the chat, somebody had a comment, and it's not quite a question, but I'm wondering if you just have any reflections on it. It says most tenants won't say if there's a problem because they're scared of being evicted.
So true. Very, very true. We see it all the time. We hear it all the time. And it's unfortunate. It's illegal for a landlord to retaliate against a tenant because they complain about the condition of the apartment. It's illegal for a landlord to give them a rent increase. It's illegal, out of retaliation. It's illegal to evict them out of retaliation. It's illegal to do anything bad to them out of retaliation because they complained. Having said that, people are still scared, and it's that's where we go back to we can tell the tenants what the law is, what their rights are, what their options are, and in the end, they have to decide what action they want to take. Sometimes we can defend the tenants in that situation, but we can't guarantee an outcome, and we can't help everybody out there. It's not enough of us to fix everything. So, if we see what we think is retaliation, we'll try to defend that tenant. But it's true, and there's no easy answer to that. Just the tenant has to decide when they're ready to pick that battle.
Yeah, thank you for that. There's another question here about legal fees. Do you want to answer that now?
We can try.
Great. So we have experience with a building complex that is charging approximately $1,700 in legal fees. Is that legal? Additionally, is it possible for tenants to avoid these legal fees, or are there any programs they can apply to for assistance with these costs?
So 1,700 is a lot for a tenant, but it's not over the amounts that we're seeing when you add up what we talked about with the filing fee, the process server fee, the actual fee that the attorney gets paid. 1,700 is right around. That's kind of a normal amount, and yeah, that's a lot for the tenant. Like I said, it depends on the case. Some cases, if the tenant has a defense, it can be negotiated down. It is, well, in settlement discussions, there are no rules, there are no laws in settlement discussions. So either side can ask for anything, and it's just a matter of what the sides agree to. If it goes to court, that's where the judge has to decide what the law is and what the legal fees are, and whether they get awarded or not. But usually we're talking about settlements. Sometimes the tenant can pay those off in payment plan if they do have to pay them. As far as rental assistance funds are out there to help people that are faced with eviction for non-payment of rent or other things. So I don't think the rental assistance funds like to specifically pay for legal fees, but if the rental assistance covers the back rent owed and the tenant just covers the legal fees, for example, or gets them paid by some other source or something, rental assistance funds are common to help fund a settlement, a pay and stay settlement. The legal fees just adds an amount that makes it just more difficult to settle. So I hope that answers the question.
Great, thank you. That's everything we have in the chat for now.
All right, thank you, Maddie. Talking a little bit more about habitability, when we talk to clients, what are their options when they have a habitability problem? And that's, assuming the landlord's not making the repairs and, code enforcement either hasn't been called or is not fixing the problem for whatever reason. What are the options for the tenant at that point? Well, they could move out and sue the landlord. If they prove that, the place was uninhabitable, maybe they can sue and get some of the rent money that they paid back. They could stay in place, pay their full rent, and then sue the landlord, like in small claims court, try to get a judge to order the landlord to refund some of the rent money. Now that's difficult to sue your landlord when you're still living under them with them. Um, People ask all the time, can I withhold my rent? Generally, we do not advise people to withhold their rent. We tell people don't not pay your rent. And the reason is if you don't pay your rent, you're going to invite an eviction lawsuit for non-payment. And now you're in eviction court and you probably might not have an attorney to defend you because we can't represent everybody. And you could be, even if you're in the right, it can still be hard to win a case if the other side has a lawyer and the tenant doesn't. So we don't advise people to withhold their rent. The law does provide a situation where it's called repair and deduct, where the tenant makes their own repairs if the landlord won't do it after multiple requests, and then deduct it from the rent. You're only allowed to do that up for 1 month's worth of rent. And again, it's risky because you could end up in eviction court defending an eviction case. So yeah, habitability, we hear that a lot, presents problems for the tenants. Oh, here's the first quiz of the day. First person to put into the chat what these are. And sorry, my apologies to anybody if this grosses you out. These are real pictures from real client.
Okay,
Maddie's anybody identified these?
we've got two guesses so far: bed bugs and cockroaches.
Bed bugs is the winner. So whoever guessed bed bugs, congratulations. Or sorry that you know what they look like. They do kind of look like little versions of cockroaches, it's true. But yeah, bed bugs are nasty little critters that get into places and make them uninhabitable, and they're hard to get rid of. So sadly, this came from a client. Just a few more points to cover here in my little bit of time I have left to present. We talked about retaliation. It's illegal for a landlord to retaliate. So I won't go over all that again, but anytime a tenant takes any action that they have a legal right to take, it's illegal for the landlord to respond with negative consequences and retaliation. Like I said, the most common one we see is complaining about the condition of the place or calling code enforcement. Landlords don't like when the code enforcement officers are out inspecting their properties and telling them they have to repair it. So retaliation is illegal. Let's just know that. Discrimination is also illegal. Protected classes include race, ethnicity, national origin, skin color, religion, gender, sexual orientation, familial status, which means if somebody has children, people with disabilities, age can be a protected category, and even source of income. And now Section 8, people with Section 8 vouchers are even protected from discrimination. I'm not going to say too much more about discrimination because that's the second part of our presentation today by Esther. But we get cases of clients complaining about discrimination, and it can be a defense to an eviction lawsuit if that's the motive for the eviction by the landlord, if you can prove it. Could be refusal to rent, could be harassment, could be differential terms or differential treatment of the tenant. If it's being done in a discriminatory way on the basis of these protected classes, then it's illegal. And of course, people with disabilities are entitled to accommodations for their disability. And again, I don't want to steal Esther's thunder, so I'm going to leave it at that and move on to my next slide. Next quiz, can anybody identify what this is? First person to put in the chat what this is. And again, my apologies if this grosses you out. I did not step through the doorway of this unit. I took the picture from the doorway.
We have a couple of guesses in the chat, but they are all hoarding.
Hoarding, yes. This is one of the saddest cases of hoarding that I saw. This was at a hotel room actually off of 101 in South San Francisco. And yeah, it's the hoarding cases for me. You probably see them also. They're the hardest and the saddest. And um, this was one of the worst ones and saddest ones. But anyway, enough of that. Just a few more slides talking about laws that support immigrants. California now protects people on the basis of their immigration status. It's been that way for a few years now, but so it's illegal to discriminate against tenants based on their immigration status, and particularly important these days with immigrants under attack like never before, sadly. But there's laws. This is a citation to various laws that apply to protecting tenants. Sorry, I'm trying to get rid of a call coming through on my call line here. So it's illegal for a landlord to discriminate against somebody on the basis of their immigration status in the application process. So somebody goes to apply for a rental. The landlord cannot ask the tenant or prospective tenant about his or her immigration status or citizenship status. Landlord cannot require the tenant or the prospective tenant to make any statements or ask for proof of their immigration status. So it's considered irrelevant to the process. During the tenancy, landlord can't threaten or intimidate the tenant because of their status, immigration status. They can't retaliate against the tenant. They shouldn't be using threats about their immigration status. They shouldn't be threatening to call ICE on them or anything like that. That's not supposed to happen. That's illegal now. They shouldn't try to use threats and intimidation, and they shouldn't be evicting a tenant, because they learned about their immigration status or they perceive their immigration status. I include the definition here because it's not just their actual status, but it's their perception. So the landlord can't say, well, if the landlord thinks their immigration status, that they're undocumented, they can't use that as an excuse. And even if they turn out to be documented here legal in the country legally, then the landlord can't use that as a defense. So, it's important these days. I remember of one case between 2016 and 2020, tenants were coming to us from this one particular property. I think it was in Pacifica, and this one property manager would strut around the complex wearing her red MAGA hat, and even that act was really considered intimidation by these tenants. So at least in California, we have laws that protect the tenants. But just, before we go too far with that, remember, landlords still have the right to screen their tenants before renting to them and using legitimate business interests to screen their tenants. And they can ask for a social security number so that they can do a credit check. They can ask for a driver's license to show identification so the person can prove who they are and to do background screening. They can do criminal background checks on prospective tenants. They can request proof of income. They can review prior rental history. They can look up court records, unlawful detainer records. So the landlords can still do this when they're screening their tenants. But if they're going to do that, they need to do it for all of their tenants. They can't do it like in a discriminatory way. They can't use these things just against people they perceive as being immigrants. So I am just about out of time. So let me go to my last slide and see if there's any final questions for me before I turn it over to Esther. I repeat again to everybody out there, if you want to have a consult with me about a particular client, about laws or anything, you're welcome to call me. My direct number is here. And my email address is here, two-tone, not supposed to be two-tone, but it's there. You can call me or contact me. I'm happy to try to talk to you about a particular client and figure out what their situation is and what they need. If you have a client who needs our services, please send them to our housing intake line. That's the 650-517-8911 phone number, or send them to our website. They can get our number there. They can get resources there, and we're do what we can for them with the resources that we have. That's my last slide. Maddie, thank you so much for this opportunity. Thank you to everybody for the opportunity. Any final questions for me before I sign off?
Yes, there are a few final questions for you in the chat, and I checked in with Esther, and it's okay for us to go a little bit over so we can answer these.
Thanks, Esther.
Yeah, so the first question that we have here is Section 8 being used to define any supportive housing utilizing a subsidy?
Sorry, can you read that one more time? I'm not sure I caught
Yeah.
that one.
Is Section 8 being used to define any supportive housing utilizing a subsidy? I think I'm reading this question as like David, when you're talking about Section 8 throughout the presentation,
Yeah.
are you using that kind of as a proxy for any subsidized housing, or are maybe there different rules for like continuum of care funded permanent supportive housing programs?
Yeah, it's a good question. Section 8 is kind of like one of those generic terms that gets tossed around. There is the Section 8, housing subsidy voucher program, which is specifically the Section 8 program. But then there's what they call project-based Section 8 subsidies, which is where you don't get a voucher, you don't go to a private landlord, you go to a building, and the subsidy is only with the building and only with that unit. And if you get kicked out, you lose the subsidy if you move out in a project-based subsidy, and those can be called Section 8 project-based subsidies. So I may have gotten a little loose with using the term Section 8. Really, it goes back to my first slide is type of housing matters, and different rules apply to different programs. The Section 8 housing subsidy vouchers have a set of rules, and the project-based subsidies have their rules, and BMR properties and tax credit properties have their rules. So for any individual, it really depends on the specific type of housing they're in, and you have to kind of start with that and go from there.
Great. Next question. Can a tenant be denied housing for getting paid cash and for not doing their taxes?
So the trick there is the landlord, takes the application and the tenant says, here's what my income is. And then if the landlord has a policy of asking for proof of income, and if they're consistent where they screen tenants based on the proof of income provided, now a tenant who only gets paid in cash might not have good proof of income. And so it's not denying them because they get paid cash, but it is at the same time because they might not have proof of their income. The landlord's concern is just that the tenant's going to be able to pay the rent. So I think it's more of a kind of a logistical proving the income problem in that situation. Was there a second part of the question? There was they're getting paid in cash, and what was the second part?
Not doing their taxes.
Not well. Let's see. A landlord's not going to know if you do your taxes or not unless their proof of income that they require is a copy of your tax return. And again, like if they do that consistently across the board, every applicant has to submit like last year's tax records to prove income. And they don't do it just against certain people in a discriminatory way, that might be legal. I don't know. Might need a real housing discrimination expert to parse that one a little further. But if it's done in a non-discriminatory way to all tenants, then asking for proof of payment, whether it's pay stubs or tax returns, I don't think that's illegal by itself.
Okay. Our next question is many apartment applications ask for a social security number. What can someone provide instead if they don't have one in order to apply for housing?
Somebody out there might know this better than I do, I think there's other types of ID numbers, a tax ID number other than a social security number. I think people can pay taxes if they don't have a social security number. I think they can get a different type of tax ID, and I forget what it's called. There's a name for it.
Somebody put it in the chat, ITIN.
ITIN, yeah, ITIN. I think that's what it is. I think the the prospective tenant in that situation might say, I don't have a social security number, I have an ITIN number. Um, if it allows the landlord to do whatever check they want to do to screen for the qualifications of that tenant. But it might be the case that landlords are using the request for social security number as a proxy to screen out um, people who are undocumented. So it's hard to prove, though, if they're otherwise screening the tenants in what appears to be a non-discriminatory way.
Great. The next question is, should a tenant provide bank account information on their application, specifically an account number and a routing number?
I think generally, no. I think generally landlords shouldn't be asking for that. That's getting a little too personal. They might ask for bank statements, but you can redact or block out the actual, the number, the account number, and um, the routing number, or like, yeah, stuff like that. I don't think landlords in those cases should be asking for that. That's not really what I do. I don't get involved in the application side. I'm usually on the eviction side, trying to keep people in their homes. So sorry if I don't have great answers to all these questions. It's not, yeah, not really what I do.
No. Okay, great. We have just one question left that I see in the chat, but I think it is better to save it for Esther's presentation because it's asking if it's illegal for landlords to refuse clients who have housing subsidies, and I think she is going to touch on that topic. So before we let David go, does anybody have any last questions for him?
Thanks again, everybody, for having me today and for your attention. And thank you for all your work you do out there to help people. And don't hesitate to contact me if I can help you.
Great. Thank you so much, David. Lots of thank yous in the chat.
Thanks
Now
again, Maddie.
yeah, thank you. Now we're going to transition to the second part of our presentation for today, which is going to focus on fair housing and anti-discrimination rules. And so Esther is going to go ahead and take that away.
Hi, is the right screen up? Does everybody see the correct screen?
Yes.
Awesome. Okay. Hi, everyone. My name is Esther Wilch. I'm a directing attorney at Home Base with Maddie. And I'm going to follow up David's very thorough and brilliant presentation by diving into just sort of two critical laws that also impact housing access and civil rights for tenants. And these are the Federal Fair Housing Act and California's Fair Employment and Housing Act. So we've got just like a couple of goals today that we're going to go through. We're going to learn a little bit about fair housing, how federal fair housing laws and California's Fair Employment and Housing Act apply to landlords' review and denial of housing applications and treatments of clients and throughout the housing process. So just get like a basic foundation about, these two statutes. Then we're going to talk about how you and your clients can use fair housing laws, understanding what your role might be in that, and sort of directing you to some resources federally and locally to help combat housing discrimination. And then we're going to, talk about how you and others can just actively enforce fair housing. So, talking a bit about partnering with local organizations that specialize in this to leverage advocacy resources and whatnot. And then also really helping clients understand their rights and assisting them when necessary. I think as somebody put in the chat and was just discussed, it can be really, really hard to get clients and get tenants to advocate for themselves. And, I think there's even an additional layer when you're talking about a discrimination claim there. So just kind of thinking through some ways that a client might advocate for themselves, and you might help them do that. Okay. So I just want to start today, sort of like getting us all centered in a place where we think about why fair housing laws and the whole sort of scheme is necessary. So prior to the 1960s, housing policies in the United States were dependent on your race and specifically on whether or not you were white. If you were Caucasian, then you could own land, you could own property, and there were programs there that proactively helped you to own property, like the New Deal and the GI Bill, and things like that. But for those who were not Caucasian, and occasionally for those who were not Christian, there were no such affirmative programs to help people get housing. And in many cases, there's a long history in the United States of there being programs that prevent people from owning or retaining their property. So this is just like a brief history of the United States and some of the laws that we have had that have impacted different people's ability to own housing. The Indian Removal Act of 1830 resulted in the forceful removal of Native peoples from their land and also the Trail of Tears. In 1851, the Indian Appropriations Act created the Indian reservation system, which, relegated Native people away from their homeland to places that were often uninhabitable or far less desirable than where they lived in order to give white settlers access to their land and natural resources. Oops, sorry. And then from that, we had slavery, which allowed whites not only to own land, but also own people, and for enslaved persons to own nothing. Eminent domain uh, is a way that the government, and it still exists today, the government can sort of claim ownership to land or something like that in the interest of the public. But historically, it's been used to dispossess African American people in the name of urban renewal, or Japanese Americans during incarceration by the government in World War II. And so, yeah, it was a way to dispossess people from their land. And then, racial covenants forbade people from sale of houses to anyone who was not Caucasian in certain neighborhoods. Redlining was a process to intentionally exclude non-white people from receiving home loans in places. And then on top of that, you just have racial profiling where, people wouldn't rent or sell to people that looked a certain way. So I just want to start us here to emphasize that it's this legacy of these policies that have shaped today's housing landscape. And they're the reason why fair housing laws exist, because history teaches us that they are incredibly important protections to have. Okay. So first, let's talk about the Fair Housing Act, which is a federal law. It is also known as Title VIII of the Civil Rights Act of 1968. And it came about as the culmination of a civil rights campaign against housing discrimination in the U.S. It was signed into law by Lyndon B. Johnson in 1968, a week after the assassination of Martin Luther King, during the riots that came after his murder. So just kind of painting the picture again for the atmosphere in which these things came to be. And it expanded on previous acts that had existed. And super importantly, it created a federal enforcement mechanism to enforce itself, right? Like there now was a way to make this enforceable against people. So basically, the Federal Fair Housing Act prohibits housing discrimination on the basis of any protected class, and it enumerates those protected classes. So originally, that only included race, color, religion, and national origin, but it has continued to expand to include sex, which has in turn been interpreted to include both sexual orientation and gender identity. It includes disability. It includes familial status and national origin. And the FHA or the Act applies to all housing, regardless of the type of funding or ownership, whether it's owned by private organizations or, I'm sorry, by private individuals or organizations, pretty much universally applies. Cool. So in addition to the federal fair housing protections, Californians are also protected by California statutes, which provide far more robust protections. So the California Civil Rights Department, which was formerly known as the Department of Fair Employment and Housing, is charged with protecting residents from a variety of different discriminations via enforcement of a number of different statutes. So today we're going to focus on the Fair Employment and Housing Act, which prohibits discrimination in employment and housing based on various protected characteristics. And also, as David was discussing, it bars retaliation against any person who files a complaint with the department or participated in investigation of a complaint or opposed any activity that's prohibited by the act. And then there's a couple of other civil rights acts that are sort of incorporated with FEHA. One of these is the Ralph Civil Rights Act, which prohibits violence or intimidation based on persons' actual or perceived characteristics. The Unruh Civil Rights Act prohibits discrimination by business establishments, and that includes housing and public accommodations. And the Disabled Persons Civil Rights Act ensures that people with disabilities or medical conditions have full and equal access to public places, services, and accommodations. And again, the CRD, the California Civil Rights Department, investigates and enforces all of these. Okay, so I said in California, the civil rights protections against discrimination in housing were a little more robust. And that's sort of what this slide demonstrates. So in order for discrimination to be illegal, it has to be against a protected class. Both federal and California laws protect people from discrimination, and the federal law sort of sets the floor for what those protected classes are, and then California builds on that and makes it, more broad. So Fair Housing Act, federal protected classes, again, race, color, religion, national origin, sex and gender, familial status, and disability. Under California, it also includes you cannot be discriminated against because of marital status, your sexual orientation, ancestry, source of income, gender identity or expression, and then under Unruh, also arbitrary characteristics, so age, occupation, immigration status, etc. So to the question about somebody having housing subsidies, arguably in California, you could not discriminate against somebody just for that under source of income, right? So yeah. And then also wanted to touch on here something that David started to touch on and then graciously punted to me, but in the case of disability, Discrimination includes failure to make a reasonable accommodation so that the tenant has full and equal opportunity to like use and enjoy the property. So usually this has to do with like the rules or regulations on the property, but it could also be things like if there's a no pet policy and somebody has, a pet who's provides them with assistance, that would be a reasonable accommodation that might need to be made. Things like parking and giving somebody an accessible parking spot. Um, Occasionally even things like, rent payment schedule to accommodate someone's income assistance, um, etc. So, yeah, all of these are the protected classes. You cannot discriminate against people for any of these reasons. Okay, who do these laws apply to? They apply to pretty much anyone and everyone in the housing process, not just landlords. They apply to property owners, both individual and corporate. They apply to property managers, maintenance and administrative staff, housing authorities, voucher program administrators, shelter program employees, real estate agents and brokers, lenders, insurers and appraisers, homeowners and condominium associations, property management, architects, builders, developers, and engineers, municipalities, etc. Basically, if you are involved in a housing transaction or habitation, you're responsible for ensuring that protected classes are not discriminated against in housing. Okay, I'm going to touch for a second on disparate impact. I'm not going to get super deep into it, but I'm going to highlight that disparate impact and then a couple of other things that we have coming up. Everything we're telling you today is sort of the law as it stands now, but things are ever changing. And so, it's important to keep yourself appraised of what changes, especially in terms of federal law. So in terms of disparate impact, a policy or a practice can be discriminatory even if the provider does not intend for it to be. So it doesn't literally need to be made in order to weed out a specific protected class of people. A policy can be neutral and it can still have the effect to disproportionately harm a protected group, and that may still be a violation of FEHA or the FHA. So, I do a lot of my work at Homebase on our criminal legal systems initiative, where we look at the intersection of homelessness and criminal legal system involvement. And one thing we see there is that, criminal justice background checks may be applied uniformly, and the person doing it may have a really good non-biased reason for doing it. But one thing that we see is that it often has a disparate impact on, people who are often Black and brown. And so that would be an example. Other examples are, if there was a rule saying you can't have any curry permitted in apartments, that might have a disproportionate impact on South Asians. If you have a rule that says no one can play outside, that obviously might disproportionately impact families with kids, etc. So a policy doesn't need to be overtly discriminatory to still be in violation of these fair housing statutes. Yeah, same caveat as before. This is still the law now, that both the Fair Housing Act and Equal Access Rule ensure equitable access to housing, but they focus on different aspects. So the Fair Housing Act prohibits discrimination in housing based on protected class characteristics. HUD's Equal Access Rule ensures that individuals are served in HUD-funded programs in accordance with their gender identity. So it prevents discrimination based on perceived sexual orientation or gender identity or marital status. Um, and specifically, it prevents HUD-funded programs from forcing individuals to disclose their gender in a way that could be demeaning or discriminatory. You can't force someone to prove their gender. Sorry, I had bunny ears at the wrong point. And it's, especially important for protecting transgender individuals from discrimination in accessing emergency shelter federal housing. I will say that in February of this year, the HUD Secretary Scott Turner issued a directive halting enforcement of the Equal Access Rule. So this could lead to potential rollbacks in protection for transgender and other individuals. But sort of TBD, remains to be seen a bit. And then following that up with, I think something that's critically important to understanding the Fair Housing Act is that there is a mandate under it that all recipients of federal housing funds take action, affirmative action, to combat housing discrimination and to promote housing choice. That is to affirmatively further fair housing. So this quotation, I'll just read it. Affirmatively furthering fair housing means taking meaningful actions in addition to combating discrimination that overcome patterns of segregation and foster inclusive communities free from barriers that restrict access to opportunity based on protected characteristics. Specifically, affirmatively furthering fair housing means taking meaningful actions that, taken together, address significant disparities in housing needs and in access to opportunity, replacing segregated living patterns with truly integrated and balanced living patterns, transforming racially and ethnically concentrated areas of poverty into areas of opportunity, and fostering and maintaining compliance with civil rights and fair housing laws. The duty to affirmatively further fair housing extends to all of the public agencies' activities and programs relating to housing. Yeah, so, the idea was that beyond preventing discrimination, agencies should take active steps to promote equity, which means addressing disparities, combating segregation, improving access to opportunity, all of the above. Okay. Okay, so that is the 30-second overview of these two very important statutory schemes. Now let's talk a bit about what your role is. So, those of you who are housing providers, your role can be to make sure that your program is not unlawfully excluding people. And as mentioned, this is not just what are you doing on the face? Do you have a law that says we don't, do you have a policy that says we will not rent to white women? Maybe not, but do you have policies that, unwittingly impact certain people in a way that is not legal? Consider that. Housing case managers and advocates, your role can be to help prevent discrimination against your clients as they are looking for housing and to, help advocate and remind your clients of these rights. Oh, sorry. Did someone have a question? No. Um, yeah. And so at the outset, those are some of the roles that you can have. And also looking at data and understanding your data, like who is being denied housing, who is being evicted from housing. And don't just look at it on the surface, dig a little bit deeper. How often is this happening? Are there specific zip codes or buildings that it's happening in? And what is the impact, right? Like, even if it looks sort of kosher or random or whatever on the surface, who is it impacting and how is it impacting there? And if you start to see a trend that concerns you, conduct interviews, do focus groups, dig a little bit deeper to try to understand what is happening and ensure that it is not illegal discrimination. If you or a client suspect that illegal discrimination is occurring, you kind of have three main options that you can take, three paths that you can take to address it. I'm going to go over them in greater detail in a second here, but at the outset, they are, doing an administrative complaint, filing a lawsuit, or writing a demand or education letter. So, an administrative complaint is an alternative to a lawsuit. You file it through a government agency, so that's either going to be HUD or CRD. You don't need a lawyer, but you can have a representative there if you need it, and it's free, right? A lawsuit, on the other hand, you file through the court system. As we discussed, even just filing fees and things like that, like David was mentioning, can be a lot of money. If you are hiring an attorney and things like that, it can get even more expensive. And in many cases, you will likely need an attorney because these things can get very complicated and very time consuming. And then demand and education letters are a less confrontational way to approach the issue. And in the case of education lawyers, education letters, you don't need an attorney. You can do that yourself. Okay, so administrative complaints, what are they? They're basically just alerting the federal agency that you feel that your fair housing rights have been violated. It's not a lawsuit, but it can be a predecessor to a lawsuit. It doesn't require an attorney or any type of representative, but you can have one if you need it, and the process is free. So this is just looking generally at how a complaint will go through CRD. You have initial contact with them through a website usually. There's an intake form, you submit it. They make an initial determination about whether or not they have jurisdiction over the case. And then if they don't, the case is closed. And if they do, then a complaint is filed, an investigation ensues, and they ultimately make a finding about, what ends up happening. So that may be, that you settle the case, that CRD prosecutes under the case, or that the case is just closed without prosecution or without settlement. And typically in California, HUD refers to CRD. So this is the most common process. A couple of tips for administrative complaints. First and foremost, and this is not just for administrative complaints, this is if you suspect or if anyone suspects discrimination, try documenting everything from that moment forward. Keep a record of everything. As David said, like take photos of everything, save emails, save phone logs, do all of it. You can contact your local fair housing organization to see what advice and support they can offer locally, but really just getting as much tangible evidence together as possible is really critically important, whatever route you decide to go. You want to provide as much detailed information as possible and keep track of all of that. Dates, times, locations, witnesses, get their contact information, get them to write down what they saw when they saw it, all of that stuff. Make sure that your complaint is based on one of those protected classes that we talked about earlier, right? Like being a redhead is not a protected class. You need to find one of the protected classes, and you need to find the nexus between what is happening and your protected class. And reminder also that at intake, when they're making that initial determination for the CRD about whether or not they have authority over the case, that's done by staff, not attorneys. So it's make it easy, spell it out for them to find reasonable cause. And if they do not find reasonable cause, you can always appeal it. Demand letters, the same tips apply in demand letters as they do in administrative complaints. I think that demand letters and education letters can be really useful alternatives to complaints and lawsuits. They can be effective, they can resolve things quickly. A demand letter is something that is typically written by an attorney and it demands some kind of specific action. And it also lays out what laws are being violated with specificity. And it says, you are harming me in this way. It is a violation of these laws. This is what I demand you do in order to rectify the situation. It has a more confrontational tone. It often comes from an attorney or uses legalese. And a lot of times demand letters are sort of the last step before a civil lawsuit is filed, but they don't necessarily need to be. On the other hand, education letters or information letters can be written by anyone, and rather than saying you are doing this in violation of this law and I demand you do XYZ to fix it, they're like much softer in tone, just kind of requesting or suggesting some type of action, highlighting that what someone is doing may be a violation of the law. There are form letters out there and templates, and they often are more non-confrontational in tone. So those are really, really good if you want to maintain the relationship with the landlord. It's sort of the least aggressive way to do it. And in both cases, these create a record, right? They create a clear record to respond to, and they set the landlord up to, I'm sorry, they create a record and they set the landlord up to respond and either confirm the facts as you stated them or deny them. But in any way, you give them notice so that they can correct things. And if they don't correct things, then you have the record there. Quickly deciding what actions to take, things to consider. What is the client's goal? Do they want to keep the housing? Do they want to avoid eviction? Do they want to get compensation? What is it that they want exactly out of this? How egregious is the discrimination? How serious is it? Is this a landlord who has done this over and over and over again? And it seems like a systematic sort of attack. Or is this the kind of thing that is just an oversight, Um, what evidence do you have? You're going to need some good evidence if you are going to take this case to trial. So consider that. What will the impact on your client be? And what is your client willing to take on? Lawsuits can be, incredibly fraught and really difficult and can go on forever. What's your comfort level if you're advocating for your client? What are your agency's policies? Um, all that good stuff. And then the last thing that I just want to highlight is that, there are fair housing centers and organizations available. They can help victims of discrimination file claims. They can help investigate and gather evidence and file complaints. They're free, and you can use that link there to the Fair Housing Alliance to find more information. And that is all that I have. Thank you all very much. And Maddie, I guess I'll pass it back to you if there are no questions.
Real quick, we can pause and see if anybody wants to ask any questions out loud. There's nothing in the chat. We have a few more seconds. Feel free to come off of mute. or you can add them to the chat. Okay. Well, thank you everyone for attending today's training. We really appreciate your time and attention to this issue. Before you go, we're going to ask that you complete a quick survey that talks about your satisfaction with this training. You should see it popped up on screen. It's a Zoom poll with just 2 questions. Your feedback on this really helps us continue to offer these trainings and make them better for you and your clients. So I'll give everybody a few seconds to complete that survey. So again, just giving folks a minute to complete the survey that they see on screen. Great. All right. And that is the end of our training for today. So again, thank you all so much for coming. We will be following up with everyone who registered for this training, including a recording of today's training, as well as the slides that we talked through. And if you will include the presenters' emails in there as well, if you want to reach out with any additional questions. Otherwise, I hope everyone has a good rest of your day. Thank you so much.
Thanks,
Thank
Maddie.
you.
Thanks again.
Appreciate it.
Bye. Thank you.
Thank you.